Major breaking news out of Florida. The 11th Circuit Court of Appeals has just agreed to hear a legal challenge brought by the National Rifle Association dealing with bans in the state of Florida on 18 to 20-year-olds being able to acquire, specifically purchase firearms. Let's talk about it when we get back. Stay tuned. Hey folks, I'm Mark Smith, host of the 4 Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. If you haven't picked up a copy, check it out on Amazon. It's also available in Kindle and audiobook. And if you're not following me on Twitter, I know you all love Twitter, but if you are on Twitter, check out @4BoxesDiner. I do a lot more Second Amendment work on there in addition to this channel. All right, folks, major breaking news. The 11th Circuit Court of Appeals, which is the United States Court of Appeals that covers the states of Florida, Georgia, and Alabama, has just vacated a 3-judge panel decision from the 11th Circuit that upheld Florida's law banning 18 to 20-year-olds from being able to purchase firearms. Now, the 3-judge panel on March 9th upheld Florida's law, saying it was consistent with the Second Amendment's right to keep and bear arms, and that 18 to 20-year-olds did not have a right to acquire firearms. And therefore, the Florida law preventing them from acquiring firearms, specifically purchasing them, was constitutional. As soon as that decision was issued by a 3-judge panel, I flagged for you that a single judge in the 11th Circuit had indicated he wanted to poll the court, the whole court, meaning the entire 11th Circuit Court of Appeals, and all the judges on it, to determine whether or not the 11th Circuit Court of Appeals should vacate the 3-judge panel that basically concluded the Florida law was consistent with the Second Amendment and have the case be heard by the entire 11th Circuit, meaning all the judges, to see whether or not the Florida law banning purchasing of firearms for 18 to 20-year-olds, whether that violated the Second Amendment. And I'm happy to report that the 11th Circuit has decided to hear the case en banc. So they've done 2 things. Specifically, they have concluded that the panel decision against the Second Amendment is to be vacated, which means it's null and void now, no longer counts, doesn't count, no longer binding law. And they're going to hear the case en banc. Specifically, this is the order the 11th Circuit issued. A petition for a rehearing having been filed, and a member of this court in active service having requested a poll on whether this appeal should be reheard by the court sitting en banc, which means the whole court, and a majority of the judges in active service on this court having voted in favor of granting rehearing en banc, it is ordered that the appeal will be reheard en banc. This panel's opinion, the panel's opinion, is vacated, which means a Second Amendment loss has been vacated. Now, I'm not surprised by this, and this is what I predicted, because I don't see how you cannot find that 18 to 20-year-olds are not protected Americans that are entitled to have, acquire, possess, purchase firearms like any other American for a whole host of reasons. But let's talk about this for 1 second. I want to specifically just make a couple points about the 3-judge panel decision and then explain why it's clearly wrong and why I think the en banc court is going to rule in favor of the Second Amendment and strike down the Florida law. To begin with, if you look at the March 9th decision by the panel, which I'll put a link to down below, they said that the most important time period for interpreting the Second Amendment was actually the late 19th century, what's known as the Reconstruction era. This is wrong for so many reasons. I wrote an entire article about this that's often cited by litigants in Second Amendment cases today. It was published in, among other places, the Harvard Journal of Law and Public Policy, a major article. It's a slam dunk article, did not require a rocket scientist to figure this out, although I put it together, and I'm not a rocket scientist, but I've still put it together, pretty obvious stuff, that when the U.S. Supreme Court applies any aspect of the Bill of Rights, including the Second Amendment, there's a couple of very basic black letter law principles that apply. Number 1 is, whether you apply the Bill of Rights to the states or to the federal government, the meaning and the scope of the right has to be the same. That's clearly the case. The Second Amendment, when you apply to a federal gun control law, the Second Amendment, whether you apply to a state gun control law, like here, the Florida gun control law, which is a state, not the federal government, the interpretation, the scope, the understanding of the Bill of Rights, including a Second Amendment right to keep and bear arms, is got to be the same no matter where you apply it. Number 2 is that late 19th century history may only be relevant as what is known as a confirmatory analytic, which means that you can consider late 19th century or Reconstruction era or 1868 14th Amendment when the 14th Amendment was adopted. By the way, just to jog your memory, the reason why the 14th Amendment is arguably relevant to this is because the Second Amendment, when it was adopted in 1791, only applied to restrict the conduct of the federal government. Only after the 14th Amendment was adopted after the Civil War in 1868 did the original Bill of Rights apply and restrict the conduct and behavior and authority of state and local governments. And that's why the anti-gunners want to talk about that 1868, because there's more gun control law in the late 19th century for them to point at to justify their gun control law today than in 1791. And of course, a big reason why that's the case is after the Civil War in the South, which, by the way, the three-judge panel that just got vacated relied heavily upon. In the South, there was an active effort by many southern states to enact what were known as the Black Codes. Because before the Civil War, slavery was legal in the South, and in those states, slaves were banned from possessing firearms without the consent and permission of their owners. And they sometimes gave that permission to the slaves for the purposes of like going to hunt or something. Nevertheless, after the Civil War, because among other things, the Freeman Bureau and whatnot, the African Americans were granted, at least in theory, the same rights as white Americans in the South, but the southern states actively tried to make this not possible by enacting the Black Codes, which required a whole bunch of gun control restrictions that were designed to, in practice, apply and restrict the rights of African Americans, and usually were conveniently ignored as applied to non-African Americans in the South. But the laws were on the book, and that's why the anti-gunners today want to talk about the late 19th century, because they want to point to those racist-oriented Southern laws, those Southern gun control laws, to say, well, see, in the late 19th century, you had these gun control laws, and therefore modern-day gun control laws are consistent with our historical tradition of regulating these firearms, and that's why they are so desperate to go there. But again, that's not how it works. 1791, in every single Supreme Court case that looks to interpret the Bill of Rights, laser focuses on the time of the founding when the Bill of Rights was adopted, including the Second Amendment. And the only thing that the 14th Amendment is relevant to is simply understand that when they adopted the 14th Amendment, the idea was that the original Bill of Rights, including the Second Amendment, was designed to apply to new groups of people. It wasn't changing the scope or understanding or the meaning of the right. It was simply changing by expanding the number of people implicated by the Bill of Rights, including it covered and protected the rights of a new group of Americans, i.e. the former slaves, the African Americans in the South. And it also applied and restricted the conduct of additional government entities beyond the federal government, i.e. the states and local governments. That's all it did. It didn't change the meaning or scope of the Second Amendment. It just changed who it applied to, both for positive reasons in the freed slaves and for negative reasons, meaning, enjoining or preventing the states and local governments from violating basic fundamental constitutional rights. Okay, so the three-judge panel argued that the late 19th century is the relevant period, clearly violating every single basic law of precedent of the U.S. Supreme Court. It was a no-brainer. I predicted this as soon as I saw it, how silly the decision was, and it's pretty clear the 11th Circuit Court of Appeals noticed this. And beyond that, the other thing, as you know, the best evidence, in my opinion, that 18 to 20-year-olds are entitled, and I can't believe the panel decided this, and this is why they got en banc and their decision got vacated, is the panel decision said that there's no evidence that 18 to 20-year-olds at the time of our founding, meaning in 1791, had any kind of right to acquire guns. They do make a reference, by the way, believe it or not, you're going to find this entertaining. The panel decision specifically says, well, yeah, it's true that Congress imposed on 18 to 20-year-olds obligations to serve in the militia, specifically under the Militia Act of 1792, which was adopted, 1 year after the Second Amendment of 1791. But and just to jog your memory, the Militia Act of 1792 says that 18-year-olds up to 45-year-olds, white, able-bodied white American males had to bring their own, this is key, had to bring their own privately owned firearms, ammunition, and black powder and the like with them to militia duty. Now let's just pause and think about this using our basic common sense and brains. If I impose an obligation upon you, as the government, to bring your own privately owned firearms, ammunition, black powder, pouches, and the like to militia musters, what does that obviously presuppose? It presupposes that you have the right and the ability to go out and buy for yourself the same exact items, i.e. guns, ammo, black powder, pouches, and so on. Because how else can I require you to bring your own stuff to militia musters if you can't go out and get your own stuff in the first place? Obviously, the Militia Act of 1792 that applied to 18 to 45-year-old white able-bodied men said they had to bring their own weapons to militia musters, presupposed that 18 to 45-year-old men were able to, and had the right to get their own guns, which of course they did. No shock here. So the bottom line is, this is going to be a slam dunk. The 3-judge panel was absurd in their ruling. It's pretty clear the 11th Circuit understood this immediately, just as I did, and I think they're going to reverse this. And what's going to be interesting here is after that happens and the Second Amendment is vindicated, and the state of Florida is spanked on this law, I think what's going to happen, and this is going to be very exciting for all of us, is that the state of Florida will seek certiorari to the Supreme Court asking that the Florida law be upheld. I think there's an excellent chance the U.S. Supreme Court is going to take this case because I think this is such an easy case for them to conclude that 18 to 20-year-olds have a right to keep and bear arms under the Second Amendment that I think this is such a layup case. I think there's an excellent chance that the Supreme Court would grant cert in this. And yes, there's enough cases out there being discussed in 18 to 20-year-olds in various circuits that I think they'll view this as sufficiently ripe and litigated that it's easy for them to take and resolve once and for all. And I think there's only one right answer, which is obviously 18 to 20-year-olds are part of the people that are entitled to keep and bear arms like everyone else that's a full-blown American citizen. So anyway, good news out of the 11th Circuit Court of Appeals. We'll see what happens. I'll keep you abreast as this case gets litigated, the briefs get filed, and the oral argument is heard, and we'll talk about what happens then. But until then, we'll see you again soon here at the Four Boxes Diner. And please subscribe, by the way. We're working hard to get more subscribers. Working hard on that, and we'd really appreciate it if you would subscribe. And again, if you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.